Today I'm sitting with Michael Kuna, managing partner at Kuna Law Firm PLLC, and he's here to help answer your questions regarding the law. So unfortunately, there are times when we need an attorney. Michael's here to help make that process easier, so you as the viewer are able to submit questions that you would like to have answered. And if you have questions on creating a will or estate questions, even on criminal law, Michael Kuna is our Ask an Attorney expert. So welcome, Michael.
Good morning, Anna.
Good morning. We have a pretty good question today. I had a loud argument one night with my wife in our very old and thin-walled apartment after she got home drunk really late. Some couple that lived down the hall and really didn't like us called 911. When the cops showed up, they talked to my wife, but I was very upset and told them I'm not saying anything. I was arrested for domestic violence, but afterwards they changed it to disorderly conduct. Ironically, my wife doesn't even remember what she said. What should I do?
Well, and I think we should start with the basic elements of criminal law. In order for you to be found guilty of an offense, you need to have both a mental state that made you make the offense and an act of making the offense. In the legal world, we call it mens rea and actus reus. Now, I'm not surprised that eventually you weren't charged with a domestic assault, because it seems to me by this situation that there was no domestic assault. Now, we have to understand how cases are charged. First, a police officer gives a ticket with an offense and arrests you, and then a prosecutor reviews that ticket, decides upon your charge, and charges the offense, which he goes with to court. Now we have to discuss the issues of disorderly conduct. Disorderly conduct is a majorly problematic offense. First, it's a catch-all offense, and second, that offense has been overcharged for years.
Wow.
The reason it's been overcharged is because it's extremely ambiguous and it's absolutely unclear. Now, you're probably asking yourself, why would anybody charge this? We call this the annoyance charge, or we call it the non-cooperative charge. When law enforcement has absolutely nothing to charge you with, but you were either annoying or most likely didn't cooperate with them and they wanted to charge you with something, it's very easy to charge you with disorderly conduct.
Wow.
Now, what does disorderly conduct say? First, when it comes to intent, you had to have the intent to alarm, annoy, or harass someone. Second, when it comes to the act, and I believe the subsections relevant to this issue are you had to do the mental part, and the physical part was either being violent or threatening, or, ironically, if you created a situation which was very alarming. However, because it's disorderly conduct, you can be charged with a criminal offense even if you were simply loud, meaning unreasonably noisy. Now you would ask, what's unreasonably noisy? And there's absolutely no clear answer for that. You see, we need to use the reasonable person test. Is a reasonable person in an elderly home the same as a college student in a dorm? Most likely not. And that's why when we get to these cases and they are charged, we have to look at the steps in court. The first step is that we need definitely to send a Rule 16 discovery request to see all the evidence that law enforcement has against you. Once we did that, we need to ask for a plea offer from the prosecutor. Not surprisingly, mostly in disorderly conduct cases, we get very good plea offers. Unless it's a very good plea offer, in this case, I will not continue with the prosecutorial office. I'll most likely go to trial. And here why it's good to go to trial in disorderly conduct cases. The only evidence that law enforcement can bring is direct evidence, meaning that law enforcement most likely doesn't see anything in most disorderly conduct cases, just like in this one. So they need to bring in witnesses to court, because unless they bring in those witnesses to court, they can't say and can't express what those witnesses told them. Now, this is an old apartment building where I presume people come in and out, and I presume those neighbors were upset that night. Would they even show up in court? Can your wife show up in court and testify over stuff she doesn't even remember? Most likely not. Also, don't forget that in the criminal system, we have a jury trial system. I'm having a hard time believing in any set circumstances, especially like this one, the jurors will actually find a guilty verdict.
Well, that's part of the benefit of having someone like yourself on their side, because if you find yourself in this situation, you need someone who knows how it works, how to get, through the proper channels, how to handle it. So I'm glad that we have you. How can someone get in touch with you if they have something like this?
Please call me directly, 701-404-7768.
All right, Michael Kuna, thank you so much again.
You're welcome, Anna.
I always love having you on the show. We learn a lot. Make sure you stay with us. Coming up next, we're going to take a look at some unique spirits, and we don't mean the Halloween kind.